Morning, everyone, or good afternoon if you're watching this in another location, or indeed watching it later on catch up. I'm Marian Boyle. I head Sullivan's UK Insurance and Disputes Practice. And today's webinar, which is our November webinar, is on strategies for preventing disputes and managing potential disputes. So if you have any questions during the course of the presentation, do feel free, please, to put them on the chat. There's a chat function and we'll be happy to take them afterwards. Or if not, I'll get back to you later, or email one of your usual Sullivan contacts and we'll endeavour to respond. So just to confirm, today's focus, it's on potential disputes, not the management and resolution of actual disputes. So once it's clear that formal dispute process can't be avoided, that's not our topic for today. So we'd be obviously happy to cover that in a later seminar if that would be of interest. What we're trying to focus on today, though, is the strategies needed to prevent disputes arising and to reduce the risk of disputes, and then in the early days of a dispute to tactically put you in the best position. So obviously it's not possible to eliminate the risk of disputes altogether, but as many of you will probably know from your own experience, disputes can be really costly. They can eat up management time and they're a real distraction from your day-to-day business, so not something that you would want to enter into lightly. So we thought on that basis it might be useful to share with you some of the issues or behaviours that we have seen that at least creates the dispute potential, or it even has actually led to live disputes, so that we can avoid that if possible going forwards. Obviously we would love to hear your war stories on this topic. So if you've got any tips that you can share with us, or things that you think it'd be useful to share, that we'd be really interested to hear them. We obviously don't have the monopoly of wisdom on this, and if you found a way to maximise your chance of negotiating your way out of a dispute, we'd love to hear from you. So next slide, please. The first topic I'm going to focus on is what I call fudge drafting, ambiguous drafting, or accepting documents that aren't clear or are ambiguous as to the issue that they're purporting to support. So what I'm talking about here is that when parties are in the course of a contractual negotiation, it's often the case that it's quite clear that the parties are not looking at a clause or an obligation from the same lens. Indeed, that they might even disagree on what the words on the page actually mean. But there is often an incentive when everyone is very keen to get the deal done to find a way to resolve the problem without the negotiations breaking down. So what I'm talking about here is where parties effectively fudge the drafting. They arrive at a compromise that they think everyone can live with just in order to get the deal over the line. Examples of that can be, for example, agreeing to a very woolly reasonable test, or a test of materiality, when actually what you wanted to do and what would be more effective to avoid disputes was to negotiate and agree with your counterparty measurable thresholds. If you decide to go down the woolly reasonable test line, what you're risking is opening up a debate at a later stage about what actually constitutes reasonableness and materiality. And do remember that when the English courts are asked to, so if the English court is asked to interpret your contract, because of course you might choose a different system of law to govern it, the English courts will consider that their task in interpreting your contract is to ascertain the objective meaning of the language that you and your counterparty have chosen to use to express your agreements. The court isn't going to give any weight to your subjective intentions, and indeed it might well be persuaded to interpret the court in a way that, with hindsight, do not serve your interests at all. So similar issues or problems are likely to arise if you're tempted to accept board minutes that are old or that are unclear or not specific to the actual issue that they're purporting to be evidence of. So it might be tempted to just say, oh, well, let's not make a fuss, let's sign, let's get the deal over the line, let's accept these board minutes. But there is likely to be a dispute should the deal progress and then go south as to whether, in fact, there was or that those documents did support that the signing parties had authority. And do always bear in mind that the approach people take to contracts differs tremendously depending on whether they are at the outset of their discussions negotiating a deal and keen to do business, or whether they've actually fallen out and they want to get out of the contract. So it's really noticeable that parties who are in negotiation meetings and want to do business together will be very pragmatic. They will work together, they will try and find solutions, whereas parties who are in dispute with each other might well decide, actually, I'm going to adopt a completely different approach to this, even if that's an approach that's inconsistent with the one they adopted in the discussion meetings. And they're also likely, if the claim is big enough, to subject your claim to the scrutiny of a very well-trained, but dare I say pedantic defence lawyer, who's going to look at your contract or your basis of the claim for authority and apply a minute textual analysis to it to try and find arguments to support their client's position. That's basically their job. And a scrupulous defence lawyer is going to be able to spot and exploit fudge drafting from a mile. So this sort of drafting, ambiguous drafting, it really is a hostage to fortune, and it's one way to increase your dispute potential. So if I might have the next slide, please. So I've called this the last minute addition clause. So what I'm talking about here is a situation where, and I'm sure we've all been in it, where negotiations have been going on for far too long. There's been lots of back and forth, and everyone's sort of heartily sick and tired of it and want to really put the deal to bed. And that pressure particularly piles up when there's a commercial imperative to get the deal done within a given time frame, that you're working to a hard time deadline. But do watch out for that last minute new drafting that gets slotted in often at the 11th hour without anyone considering carefully whether the language that drafting employs is consistent with the terms used in other parts of the contract. So what we always strive to do in our contracts is to avoid language that expresses overlapping concepts but use different words to do that. And when it's late at night and the meeting's gone on a long time, you might think, oh, I can just look at that clause in isolation and I can focus on its plain and ordinary meaning, and it obviously means X. But it's a very brave person that can remember the entire contract, if it's of any length, and know without reading it in context that that clause fits in with the overall scheme of the drafting, and in particular with the definitions used. And you will find, if you're before an English judge, that if you use a different expression to cover a concept that's described elsewhere in different terms, that a judge might well be persuaded that something different was intended by those different concepts. This issue also arises when, at the last minute, someone new is involved in the drafting, or someone who hasn't done the bulk of the drafting starts suggesting a clause. We all, as humans, have our particular choice phrases or way of expressing something which we think reflects with perfect clarity what we're trying to achieve. But using that sort of expression or technical language that might mean different things to different parties can often be a recipe for dispute. So absolutely accept that a perfectly drafted, entirely coherent from start to finish contract, that's difficult to achieve. I couldn't resist adding this little quote from one of our eminent judges that describes us as drafters as pilgrims on the endless road to unattainable perfection. So accepting that unattainable perfection is indeed unattainable. What we of course try to do is do our very best, and that last minute new clause that hasn't been considered for consistency with the rest of the contract is not a good idea. It's always useful or important to bear in mind that the fewer the words, the less there's to argue over. So what we always say is draft as economically and as tightly as possible. Of course, it's lovely when reading prose to have variety of language, but in a contract, elegant variation is not a good thing, because for the reasons I mentioned earlier, you risk the judge reaching a conclusion that you must have meant something rather different to that you intended because you used a different phrase or different expression. And it's also really dangerous to assume that as a matter of common sense, a judge or an arbitrator or an arbitral tribunal will come to your aid because in your eyes, what your counterparty is arguing for just lacks any commercial sense or doesn't accord with common sense. It's a very dangerous approach to take, because you might find that your trial judge is nowhere near as commercially minded as you imagined he or she might be, and indeed is unlikely to be as commercially experienced in some of the newer and more recherche areas of financing that you might be involved in. So bolting on last minute clauses leaves you at the mercy of an outcome that you might well consider is far from commercially reasonable. So next slide, please. So what I'm talking about in this section is deviating from the contract and the interlocking concepts of waiver and estoppel. So we often see disputes that arise out of the fact that the parties agreed documents which were drafted assuming they'd be used for one sort of structure, but where the parties over the course of time have used it to implement a rather separate structure not contemplated in the original drafting. And the problem with properly failing to record the variation from the original drafting is that when something goes wrong, you don't have that contractual framework or that appropriate contractual framework within which to assess what your rights are and what your counterparty's obligations are. So always bear in mind that there is a very respectable, long-standing body of English case law that supports arguments that you might be precluded by your conduct from asserting that you're able to rely upon your wording if your counterparty can show it acted reasonably in reliance on your conduct. And that's connected to this interlinked issue of waiver and accepting defaults without putting in place a reservation of rights. So, as is probably well known, English law recognises the doctrines of waiver and estoppel. And it's important to bear in mind that although those are similar concepts and they operate in a similar way, they're also different. So we can't use them interchangeably. Waiver and estoppel can take up whole textbooks on its own, so I'm not going to delve into great detail, but it's important to bear in mind that if you subsequently wish to rely upon a contractual breach in order to enforce a legal right, you might well be faced with an assertion that you've waived the right to do so. So just as a reminder, waiver by election is where it's alleged you've waived a contractual right by making some sort of unequivocal representation that you don't in the future intend to stand on that right or to enforce that legal right. So e.g., you can be said to waive your right to terminate for breach of contract. So what's key here is that the representation can be by words or by conduct. So while having some drafting in your finance documents that says delays doesn't mean waiver is useful, it may not assist if you've acted in such a way as to affirm the contract. In the case of waiver by estoppel, it has to be demonstrated by your counterparty that it relied upon your unequivocal representation and relied on it in a way that it would be inequitable and reasonable to permit you to go back on that. So we see this sort of problem arising where your borrower approaches you seeking a waiver of some provision in your documents. Often it looks like it's a relatively innocuous request. So, for example, a request to waive a particular provision in your facility that your counterparty provides you with certain types of information within a given timescale. Such requests should never be treated casually, because you need to understand, in our view, the problem that's given rise to the waiver in order to, that's given rise to the request that you waive, in order to understand the context for it and to understand whether you should be asking more questions or indeed how to act. What you're concerned about here is, of course, is that might be the start of a more serious or indication of a more serious default. So it's absolutely key to be rigorous in the way you deal with waivers. It's dangerous to adopt the optimistic, it will all work out in the end approach. And it's always worth taking time to think through the issues. So if, for example, you're asked to forego notifying a third-party bank over security of your security over an account, everything's going along swimmingly, you might be tempted to agree that, but you're likely to find that if the deal goes pear-shaped, that bank will in future refuse to follow your instructions without the account holder's consent. And if your account holder is in default or heading that way, that might be impossible to obtain. So effectively defeat the object of the security. So we always recommend putting waivers in writing, and we always recommend putting in a defined period for the continuation of the waiver, and that's spelled out really clearly. Otherwise, if you don't have the evidence, it's very difficult to establish what the extent of the waiver is. So are you waiving all breaches resulting from one particular event, or is it limited to a specific event? Having that sort of debate later in the context of a dispute is never going to be fun. So new slide, please. Another area that can lead to very costly disputes is failing to agree a choice of law to govern the contract, or failing to agree an effective method of dispute resolution. Do bear in mind that these are two different things. So choosing your choice of law isn't the same as choosing your jurisdiction. So you really do need to think about them both. I accept that this sort of boilerplate gets left to the end of the negotiations. And often everyone's a little bit exhausted with the debate by that stage, and it's not given possibly the thought it should. But where your contract is with a counterparty in another jurisdiction, or where performance is going to take place in another jurisdiction, not sorting this out can be quite high risk. So, for example, if you don't choose your governing law, you risk your counterparty commencing proceedings in that jurisdiction. And it will be that other court, so the court of his home jurisdiction, for example, that will then have to make the evaluation as to what's the correct governing law of the dispute according to that court's rules, which might be very different to the approach that an English court would take. So while it's fair to say that most developed jurisdictions approach this question by looking for the country with which the contract had its closest, and it's called the closest and most real connection. But that's not the case in all jurisdictions, and some jurisdictions will imply a choice of law based on other factors, including it might be evidence as to the party's intentions. Similarly, it could be said that there are a number of competing options as to what is the most convenient forum for a dispute to be determined. So if you've got more than one proposed defendant, that factual inquiry can become very complex, and trust me, you can run up a lot of legal costs debating the issues, particularly if this is a contested application, and that's before you get to your legal spend on trying to resolve the actual dispute itself, the true issues. So we would always recommend you avoid this if possible, because counterparties can exploit the lack of a jurisdiction clause by commencing their proceedings in a jurisdiction that's friendly to them, so preemptive strike, to try and get one court that approaches the dispute in a way that assists their position to accept jurisdiction. So, you know, for example, your counterparty might know very well that its home court always adopts a very restrictive approach to disclosure. And if you know that your dispute is going to turn on what documentary evidence is available in the other side's hands, the last thing you want is to have your dispute being tried in a court that rarely requires parties to produce documents, or simply doesn't have that sort of rule and would never contemplate it, and would equally never contemplate a request for production of documents from third parties that might well be available if you were having that dispute tried here. So, you know, cynical opponents do jump the gun and they issue proceedings in their home courts. And they do that because they know that some courts may not employ the sort of active case management that the English courts do. English courts will impose sanctions if you miss procedural deadlines. Not all courts approach like that. Courts can be quite casual in allowing, you know, endless adjournments. And there are some jurisdictions that have multiple level of state and federal appeals. That means you're going to be tied up in a dispute for years and years and years before you get an outcome. And you know that will be a burden that can be avoided if you bite the bullet at the outset and try and agree a governing law and jurisdiction clause. Now, I absolutely accept that sometimes it's controversial, and absolutely accept that for short-term trade instruments, LCs, the practice is probably not to have a choice of law clause. But the risk of doing that needs to be appreciated, so that this is an eyes wide open risk that's being taken. Because if you don't choose a system of law to govern your contracts, your counterparty might well start proceedings in another place that has a system of law much more favourable to it than adverse to your position. I know these clauses aren't a priority. I absolutely accept that as a litigator, but perhaps in these negotiation meetings, it might be motivating to think about the terrible waste of money involved in a disputed application, or to think about what would it actually be like to litigate your dispute in a foreign court. So what you have to think about here is you're not going to be familiar with the procedure. You're not going to be familiar with the substantive law. You'll need fresh advice on that. The location might be wildly inconvenient for you and your witnesses. It'll all take place in a foreign language. It might well be that the quality of the judges is such that outcomes are unpredictable, so your local lawyer can't even give you, you know, a fair assessment of the risks, and there might be multiple appeals possible. So if you've ever had to experience that in practice, I think it will bring home that it is often significantly less painful to have that difficult negotiation at the outset when your relations are cordial and you're both incentivized to reach an agreement, and not when the dispute has arisen. And even if you're not able to reach an agreement as to a court system that you're most familiar with, you know, for example, you might really want the English courts to hear your dispute, it's going to be much better for you to choose the governing law of another state with at least a predictable and strong rule of law approach, and where dispute resolution procedures well developed. So, you know, it may not be your first choice, but it's an infinitely better choice than no choice at all. And it's equally important to check that your choice, your jurisdiction clause is well drafted. Choice of law clauses are quite easy to get right. Jurisdiction clauses can be a little bit more tricky. So you want to make sure it will cover all the disputes that are likely to arise from your contract. So, you know, for example, if you feel that you've been misled into providing a line of credit because maybe the controlling shareholder or company director connived with employees to give you false statements that effectively gave a misleading impression of its strength, your claim might well be based in tort, or you might need to support it in tort to maximize your damages. And that cause of action simply may not be recognized in some jurisdictions. So you might be faced with having no remedy if you haven't chosen a governing law. And that might be the case even if you can show that the English courts have jurisdiction. So English courts will only apply English law by default. So if neither party to the litigation advance a case that a foreign law is applicable, of course they'll apply English law. But if your opponent can persuade the courts that foreign law is applicable to the obligation, then it will be the duty of the English court to apply that foreign law. And looking back on my tortious example, you might find that your opponent is saying that under the law of the most applicable, the applicable law of that particular relationship, there isn't an equivalent remedy in its home court, so you're left without any remedy. And even having English courts decide a dispute subject to foreign law can in itself, it's not ideal. It can lead to some feeling of injustice. So always bear in mind that if you're not litigating in the same country as the law to which that country relates, the evidence as to law has to be given, or is almost certainly going to have to be given by way of expert evidence. So if you think about it, if you're in another jurisdiction applying that jurisdiction's law, there's going to be a possibility of appeal, might well be multiple appeals. But where the English courts take a decision on foreign law that's based on fact evidence and expert evidence, the appeal court is very unlikely to interfere with the judge's findings on those issues, because they're considered to be matters that the judge is much more appropriate to decide. So before leaving this topic, I also want to highlight the importance of making sure your dispute resolution clause does actually work properly. So we often see multi-tiered dispute resolution clauses, and that's fabulous. They provide a series of steps that the parties go to before you can refer the dispute to the court and arbitral tribunal. And that's super. It concentrates the minds, makes people try really hard to try and resolve the dispute in what is clearly a much less adversarial setting, and that's only to the good, particularly if you want to preserve your commercial relationship. That's going to save you time. It's going to save you probably masses of management time. But do bear in mind that if your drafting isn't tight enough and your defendant wants to mess around, they have free rein, if the drafting isn't tight enough, to prolong the negotiation stage and claim that you can't yet refer your dispute to arbitration as agreed because you have not completed the negotiation stage. So you need to make sure that time limits are set out clearly. So, just to wrap that up, jurisdiction choice of law disputes are a very costly sideshow. They'll make a really serious dent in your legal budget before you even get round to the substantive issues in dispute. So we strongly recommend that they're avoided if you can possibly negotiate this. So that concludes the looking at avoiding disputes. So this next section, so for the second half, I'm going to look at what strategies you might want to adopt when a dispute looks like it's brewing, what sort of strategies you should implement. So next slide, please. So the focus on this is on resolving potential disputes and avoiding, the common bear traps that might impact your prospects of success if you can't actually find your resolve early days and you ultimately end up in litigation or arbitration or another alternative form of dispute resolution. So the first stage, I think, is that you should try and establish in your own mind what are the key legal issues and what is the key evidence. I personally, I think this is really, it's difficult to emphasize how important this first step is. Understanding as early as possible the legal landscape in which you're going to be having your dispute is really important, and collating that key evidence and the contemporaneous evidence gives you an enormous tactical advantage over your opponent. It can mean the difference between winning and losing. It can also mean that your dispute is much more easy to resolve. So assuming your dispute relates to a financing, first thing to do is to check that you've got complete and executed copies of all your agreements. If there are steps required to perfect your security, for example, registering with a particular authority, that's all been taken. If there's particular formalities that needed to be complied with in the borrower's jurisdiction, that you've got evidence those steps were taken. So, it might be, for example, that the security had to be signed in a local language, or that there had to be witnesses. Check, you can work out who the witnesses are. And if you haven't retained evidence, or you can't put your hands on the evidence, then obviously that should be dealt with as a matter of priority. And for security located elsewhere, obviously you're going to need local legal advice. So next thing to think about is, what evidence are you likely to need to assist you in the resolution of the dispute? And this is something where you definitely need to work with your in-house lawyers or external lawyers, because in trying to work out what these legal issues are, you do not want to run the risk of creating new documents that might have to be disclosed in subsequent litigation because they're not protected by privilege, that aren't helpful, that actually might damage your case. So I'm going to have a separate slide on privilege shortly, but that's important to keep that at the back of your mind in considering what I say to do with this slide. So collating relevant documents is absolutely key, and as is preserving that contemporaneous evidence. Now, of course, witnesses of fact can give evidence orally, but it's absolutely fair to say that judges have always been more persuaded by contemporaneous documentary evidence rather than evidence from a witness about their recollection of some historical events. And I think over the last 5-6 years, that trend for the judges to give more weight to documents than witnesses has done nothing but increase. So the fallibility of human memory is well established, but there have been lots of recent studies undertaken by very eminent psychologists that have only reinforced what the judges have long suspected, frankly, and that's that human memory, human nature probably as well, human memory is fragile and it's malleable. And we now know far more from recent studies about the relative ease with which our human memory can become inadvertently distorted. So what I mean by that is people's recollection can be influenced, and we can't proceed to look at how we evidence something by assuming that a memory is just filed and can be taken out and it's perfectly preserved when the evidence is regurgitated, because it's quite clear that how we remember and how we recall past events is a dynamic process. And the more often we recall it and tell it, the more it's likely to be changed. So it's also changed if you interview witnesses as a group, and if you ask people to revisit events over and over again. What you're going to do is get into the territory of impairing the witness's memory rather than improving it. So it's really important, if that dispute looks like it's brewing, or you become suspicious that your counterparty's behaving rather oddly, to make sure everyone who's dealing with them makes a contemporaneous note as those events unfold, because those notes, those contemporaneous notes, are going to be viewed as much more accurate than their later oral evidence. And now, for reasons I'll come back to, but basically disclosure, those notes shouldn't include any commentary, just facts. So there should definitely be no casual evaluation put in those notes. There should just be a record of what the facts are. And equally, you should make sure that none of your employees exchange emails or create documents discussing the dispute or the circumstances leading up to dispute, because that might well be disclosable. So judges definitely will view your witness as being much more accurate if he or she is relying on contemporaneous notes. And the second key takeaway here is that it's absolutely crucial, as soon as you see a dispute arising, that you preserve the relevant documents. So if you've got routine document destruction procedures, they've got to be discontinued immediately, and everyone in the organisation needs to be aware that a stop notice has been put in place. Nothing can be destroyed. And now, by the word documents in our digital age, I'm sure we all appreciate that's just not paper, but it's any medium on which information is stored. So computer systems, electronic devices, your phones, backup storage, anything stored on your servers. And everyone should be aware that English judges in particular take a really dim view of parties that let litigation be destroyed after it's clear that a dispute was in contemplation. They'll just make adverse findings. They're likely to make adverse findings if they find out that that's the case. So we've got to think about this really carefully and think outside the box. So if you know, for example, that the person that that's been dealing with your counterparty regularly travels and they create documents outside your organization's computer database. So they might have a record of notes on WhatsApp, or might be even on personal computers, although of course that should be avoided for all sorts of reasons. It's really important that those are all captured, and equally important if one of your key employees is due to leave sometime soon, or we can go on an extended leave or change roles, that you need to know where they've stored the relevant information, and also drill down to, what is their practice in handling emails. I suspect we've all got little quirky filing methods, but we want to make sure that all these methods of communication are captured and preserved, including, if necessary, social media sites. Experience has shown us that even the most loyal employee is going to be reluctant to devote the time it takes to go through witness statements with you once they've gone on elsewhere. So try and get that information preserved early days. Also think about whether relevant information might be stored in in the hands of third parties. So, if you have some of your document storage is handled off-site by a third party, they too need to be aware of the stop notice. Nothing can be destroyed. Most litigation lawyers will tell you stories also about the pain of obtaining documents from backup files. So I can't tell you how many times I've been told that, oh, don't worry, it doesn't matter that employee has left because we can get all the email traffic from the backup data, only to find then when you actually ask for it that the software necessary to retrieve it has been retired, or the licenses have expired. And obviously it's possible IT consultants can retrieve seemingly endless amounts of buried information, but it's an eye-wateringly expensive experience. And it regularly gets you the data back in the order and in the same manner as it would have been originally in the email box. And once it's out of order, it can be a real pain and very costly to get it back into some cohesive order. So if you can avoid that hassle and costs, I really strongly recommend you do so. So next slide, please. I promised I'd have a little whip through privilege. So in many jurisdictions, not all of them, but in many, you've got an obligation to disclose documents relevant to the dispute during the course of the litigation or the arbitration. And if your dispute might end up in one of those jurisdictions, it's important to keep these in mind at the outset. So under the English rules, you've got a duty to retain all potentially relevant documents from day one. And remember, documents under our civil procedure rules is anything on which information of any description is stored. So this is why you need to put in place that stop document destruction procedures. And equally important is to make sure no new documents are created unless they're protected by privilege. So just to remind ourselves of the rules on privilege, and bear in mind these are as they apply under English law, I'm going to look at legal advice and litigation privilege. I will touch later on WP without prejudice privilege, but for now, legal advice privilege, that's the head of privilege that covers confidential information. So you can't share it with third parties, otherwise it won't be confidential. That's passing between a lawyer and his or her client, if that's created for the dominant purposes of giving or getting legal advice. Bear in mind that not every employee in a large organization is considered to be the client for these purposes. And this might be something you do need to take specific legal advice on, because the decisions on this from the English courts are quite complicated. So the other relevant form of privilege in our context today is litigation privilege. That's broader in some senses than a legal advice privilege, because it attaches to communications between the client and the lawyer, or between the client and a third party, or between the lawyer and a third party, if those came into existence for the dominant purpose of giving or collecting evidence or getting legal advice for use in litigation. So for this head of privilege, that litigation must be pending, or must be in reasonable contemplation of the communicating parties. So it's always useful to think about how you record that. When you cross that threshold, is litigation now reasonably contemplated? But as you'll see, those rules are quite narrow, and therefore everyone in your organisation, and if appropriate, any third party, needs to be aware of the dangers, not only of avoiding destroying documents that could be potentially relevant, but also of creating new documents that aren't protected by privilege. So everyone should know, can't discuss the events, can't add manuscript notes. Make sure that they're aware, particularly that casual communications, WhatsApp messages, they're equally disclosable. And it's going to be the job of your opponent's lawyer to sift through all your disclosure very carefully, to find communications that supports their position and hurts yours. So try and avoid giving them the gift. So next slide, if I may, Holly. So what I'm talking about here is at the outset, making sure you think about how you're going to enforce your rights, your judgment if you get it, or your settlement. So you need to know what the financial position of your counterparty is. You don't want to waste all that management time and legal budget litigating only to find that there's no money at the end of the trail to meet your claim. So start checking as soon as possible they've got financial resources. If there's some sort of backup guarantee from a third party, equal amounts of effort should be made examining their resources and ability to meet the guarantee. Do you know where your counterparty's assets are? Do you know who might owe them money? Work out how many other creditors they have. Is there some way to do that? Knowing the location of those assets is really invaluable, particularly if you know there are competing creditors and you need to move quickly. And on that note, you need to think about early days, whether you need injunctive relief. So if you fear there's going to be a dissipation of assets, or that your counterparty might well be disposing of evidence to try and defeat your judgment, you can apply to the court. English courts have very wide powers to grant these sort of interim measurements. They can grant interim injunctions, reasoning injunctions, search orders, make orders for specific disclosure, etc. And they're very useful if you do have cogent evidence of some sort of intention to dissipate the assets or destroy evidence. Usually the English court will only make those orders relating to property within the jurisdiction, but in exceptional cases they will make a worldwide freezing order. And they also might grant interim relief, usually in the form of freezing, in aid of legal proceedings that are started elsewhere. So it's important to think about whether that is a real risk in your case. Obviously, if you've got security in another jurisdiction or assets are in another jurisdiction, you're going to need local law advice. And the last bullet point on this slide is about Norwich Pharmacal orders. These are very useful orders that can be applied for where you think you have a course of action, but you don't know the identity of the person who should be named as the defendant. So, for example, you know that someone's wrongly taken delivery of a cargo over which you had security, but you're finding the discharge agents reluctant to give you the information. So, in the circumstances, you can apply to the court to order that third party who's clearly been involved in some way, for example, the port agents employed to handle a consignment, to disclose the identity of the party who collected it, or whatever other information you need to assist the claim. So our next slide, please. Always early days, think about time limits. So to check that your claim is in time. So as you know, most jurisdictions have rules regarding limitations of actions. They're designed to stop people having to face stale claims when the evidence is hard to collate and witnesses have all moved away or no longer available. But beware being lulled into the false sense of security that our relatively generous English limitation periods provide. Here, as you probably know, we looked at the Limitation Act 1980, and we've got general rules that for claims in contract and tort, we've got 6 years. That's 6 years from the accrual of the cause of action. So there are exceptions for torts like libel and slander, which are 1 year limitation periods, and for personal injury, it's 3, but otherwise 6 years, which is a relatively comfortable amount of time. Cause of action on breach of contract arises when the breach takes place. In tort, it arises when the damage occurs. Courts do have specific rules about when breach occurs. So for some contracts, it's when you enter into the contract, but there's deemed to be breach, so that's got to be watched. If your agreement is under deed, you have a luxury of 12 years. So, that's a lovely long period in which to work out what you want to do. And if there's been deliberate concealment, we have rules to extend the laws, but bear in mind, the rules, but do bear in mind that commercial contracts frequently stipulate shorter time periods within which claims might be brought. So in a cargo misdelivery claim, Hague-Visby rules are often incorporated. And there's a 1-year default rule for claims to be brought against a carrier, for example, which starts to run from the date of actual delivery. Comprehensive non-payment insurance, which often is bought by banks, often has a 2-year time period within which to bring action against insurers. So these types of contractual limits do need to be noted in diaries, and I would suggest you notify them in put them in multiple people's diaries to make sure that they don't get missed. And always bear in mind, of course, that other jurisdictions have different time limits. And if your security is located elsewhere, you need to know what they are. Next slide, please. So always consider whether you might have an insurance policy that covers part of the claim. You do need to look at this quite quickly, just to make sure the policy wording is reviewed promptly. Remember that insurance can often be held at group level. So if you're a large organization, it's worth inquiring further up the chain to make sure that there isn't something that needs to be notified to a different policy that you haven't really got your head around yet. First thing to do is establish what's the claims procedure. Often policies have quite tight limits for notifying circumstances. So they say that circumstances giving rise to a claim must be notified immediately or without delay. And sometimes they can be drafted as a condition precedent to insurer's liability. So don't treat them casually, because any delay might inadvertently risk you not being able to make the claim. Some policies also give insurers substantial control over the claim or potential claim. So you might find that the steps that we're discussing today have to be taken in consultation with insurers. As I say, always with insurance, there is absolutely no substitute for reading the policy wording and working out what your obligations are. Okay, so final topic I'm going to cover today, if we can move to the next slide, please, is negotiation. So, of course, that's the opportunity to negotiate a settlement exists throughout the course of all the disputes. And you can have, your claim going through litigation and arbitration, and have settlement discussions on the side or mediation on the side. But we would always recommend that you think about pre-action settlement discussions, because it avoids costs, it avoids damaging your business relationship. And even if you don't have the sort of multi-tiered dispute resolution clause I mentioned earlier, exploring the chance to negotiate your way out of the disputes is always useful. You can start on quite a low-key basis, so seniorish personnel, and then moved on to assisted negotiation, so a mediation. Just to explain what that is in our context. So a mediation in this jurisdiction is generally where you have an independent mediator appointed, and the parties have normally an opening session where they get it all off their chest, and then they go away to their little rooms, and then the mediator does a sort of shuttle diplomacy between them, to try and bring the parties together, and suggests, maybe having another little sub-meeting to discuss particular issues, breakout meetings for individuals who are skilled in certain issues, particularly if it's a technical issue. And what they're doing there is to try and find, a basis to bring the parties together, and ultimately to see if you can agree on a number to make the dispute go away. And this can be really valuable. We've had multiple cases that have gone through mediation where the parties have been able to resolve their dispute without having to go through a full court hearing or arbitration. And it's definitely saved time, and it's definitely saved money. And even if you can't resolve the whole dispute, you might be able to limit the areas of dispute, or get a better understanding of why your counterparty feels very strongly about an issue. So even if your mediation isn't successful, it's often a valuable dispute in terms of understanding the party's motivation and what their dynamic is. Obviously, that doesn't mean you've got to take ownership of their dynamic, but it's a people business, and reaching a settlement with the other side, it really helps to understand where they're coming from. I think the final issue to mention on that, if you do arrive at some sort of settlement, it's really important that you document it, because the last thing you want is for you to think you've settled everything and you've accepted a sum of money and walked away, only to find that actually there are other issues coming out of the woodwork, and you get another claim that you thought was encompassed within your settlement discussions, but the other side don't. So always make sure you do record that carefully, just as with waivers. Just make sure that it's clear what you've agreed and what you haven't. So things to think about when contemplating these negotiations. It's always important to make sure everyone in your organisation is on board with what you're trying to do, and that you've got agreed party line as to what's your commercial objective and what your parameters are for reaching a settlement. So what we don't want to do is to get deal regret later when you've agreed to settle it and find that other parties take a different view of what the correct number was. It's always useful at that stage also to think about who's going to be best placed to handle these negotiations. So, on the one hand, you might think, well, actually, you want the people who know each other best in the room together. But if you want to carry on doing business with that counterparty and those discussions fall apart and it all gets very acrimonious, that might damage that business relationship. So that does need to be given some thought. Obviously, it's got to be someone quite senior within the organisation, but on the other hand, you don't probably want to put in your big guns first time around, because then you haven't got anywhere to escalate it to. So just as with these tiered dispute resolution clauses, it's discussed at first level by senior management, and then it can be referred up the chain for the CEO or the MDs to have a meeting or a second attempt to try and settle. So as I mentioned earlier, there is a head of privilege that's relevant to this, and it's called without prejudice privilege. Now, I can't emphasize enough that this is a matter of English law, and you will find that other jurisdictions have different rules on this, as indeed they do on other areas of privilege. So you can't assume that this applies equally in any jurisdiction. But as a matter of English law, any genuine attempt to settle a dispute will be protected by this without prejudice privilege. We always recommend that you head your documents. So if you're writing or emailing the other side, put the label without prejudice on, so everyone knows that this is you making a genuine attempt to settle. If you're meeting with them or you've got a call with them, then make sure again that they understand that your discussions are taking place on a without prejudice basis, and make sure they understand that that means that no party can rely upon or reduce evidence of those communications if you subsequently end up in court. But again, that those rules won't apply in all jurisdictions, so it might be sensible to get local law advice on the extent to which without prejudice is a privilege head that would attach in other jurisdictions. So I know, for example, in some jurisdictions, that sort of privilege would only attach to formal lawyers discussing, whereas what I'm talking about here is attempts to negotiate done at a client-to-client, principal-to-principal level, which often keeps the heat down and means settlement is much easier to achieve, rather than getting lawyers interested in the knotty legal issues that are fascinating to them, that are going to cost you a lot of money. So if you've got any doubts about privilege, then obviously you need to make sure when you embark any settlement discussions that you're not making any admissions that might be considered as undermining a key aspect of your case, because you don't want that to be brought up later in proceedings. So I hope that's been a useful summary of the issues to look at in managing disputes, and that if you found yourself in this position, it might be of some assistance to help you resolve them and avoid some of the pitfalls. I've actually taken up quite a lot of the time. I'm just going to look to see what the questions are. So absolutely. So first question is about what is required in a particular jurisdiction by way of evidence of hard copy signatures, wet signatures, or DocuSign or soft copies. It's going to depend on what jurisdiction you're in. So something on which you need local advice. Is the second question is there a reasonable prospect of getting an injunction for breach of contract if arbitration has been chosen? So again, it depends where you are. The English courts are very arbitration friendly, by which I mean that if there is cogent evidence the parties agree to arbitrate their disputes, they will certainly give you an injunction to stop someone litigating it. But of course, it might be that your party has gone elsewhere and issued proceedings elsewhere. And although an English court would listen to an application for a prohibition on proceedings being issued elsewhere, other courts in other jurisdictions may not accept it. So again, very fact specific. So thank you for those questions. If anyone has any other issues, we'd be very happy to take it. We're coming up to time now. Thank you very much for listening. We are going to have a December webinar. I believe that we've agreed on 15th of December. We are contemplating doing a roundup or a key roundup of issues throughout the year, or key cases that be of interest. But if you've got any ideas of topics, and then please do let us know. And thank you very much for your attention, and enjoy the rest of your days. Bye now.